What's happening, gang? You are back live in the Secret Stash, hanging out with Jesse Ibanez, co-founder of the Greenhouse Group, and flanked by my new best friend, Marilyn Shea, owner of Estate Preservation Group. You can catch Marilyn out at estatepreservationgroup.com. Marilyn's hanging out with us today because I think what's true for both of us is you could imagine that there are things that go well and we love that stuff, but unfortunately when it comes to money and real estate and family dynamics and stuff, well, unfortunately the opposite usually occurs. And when stuff doesn't go quite as planned, you got to have the documents in place, as Marilyn said during the last segment, to make sure that everything still goes smoothly. And Marilyn is in here today to talk about making sure that we do not delay to begin our estate plan today. I love that thought. It's got a little ring to it too. So Marilyn, appreciate you hanging out. Now, in the last segment, man, we hit like a potpourri of a bunch of different things, right? A lot of what you do, how you do, what makes you different. So one of the things that's germane to, I guess, what we do on a daily basis is how people hold their properties and title, and some of the unintended consequences that go along with that. So would you not agree? I mean, that's a big part of what you do too, is it not?
Yes, it's extremely important. Lots of clients come see me, they have their property in joint tenancy, for example.
Well, and even before that, if we might. So like a lot of people think that a will is enough.
A will is not enough. You know,
right?
A will says who gets the stuff, but it's like having an engraved invitation to the probate court. Whether you have no will and you're intestate, or you have an actual will that's signed and witnessed in front of witnesses, that's fine for what it is. But it will go through a probate court process. We're talking about hundreds of thousands of dollars, perhaps, at least tens of thousands. Just a normal family in San Diego going through the probate process will cost about $40,000 to $50,000.
It's incredibly debilitating.
And we're talking about might take 3 years or more because of the delays with the budgets and such.
And it's dynamic too, because the more your estate's worth, the more they hit you.
Right, and it's public.
Yeah.
So we want to avoid that. And so having a trust will avoid probate. And it's a private document, and it's not public. The will is public. It's, you know, after you die, it goes to the court.
Yeah, well
Everybody
said.
can go read it. In fact, that's how the paparazzi find out about various estates, is because the will is a public thing that's published. The trust is private, and it's you and your spouse saying who you want to get things and when you want them to get it and under what circumstances you want them to get it.
Speaking of being public, we're actually streaming this entire conversation live right now, Stash Nation. If you want to go over to our Twitter handle at Follow the Stash, you can ask any question for Marilyn live right now in case this conversation is resonating with you. Engineer Steve, did we have someone on the line? Yeah, so are you want to take a call?
Sure.
Yeah, okay. Who's on the line for us, Steve?
Hello?
Yes, hello. You're on with Jesse Ibanez and Marilyn in the Secret Stash. What can we help you with?
Yes, I'd like to ask Marilyn Shea a couple of questions, if I might, please.
Well, Marilyn, here you go.
Hi, Marilyn. I'd like to know where the idea of living trust started and how long they've been in existence.
Well, you know...
Oh, wow, a little history lesson.
Okay.
Here. We got a history
They've
buff on the
been
call.
in existence in the United States since Patrick Henry.
Oh, boy.
So we're talking about a long time. In fact, they came from the Middle Ages of England, they had them. But they've been around in the United States since Patrick Henry. How long is that? 300 years?
Your guess is as good as mine.
Yeah, it's a long time.
Yeah.
And you had a second question?
The second question is how long they've been in existence.
Well,
Yeah.
Since the Middle Ages of England, they've had some version of this, okay? So I thank you for your call, and I hope I answered your question.
You did. Thank you very much. I appreciate your time.
Nice work,
Okay.
Marilyn. That was
All right.
great. God, you didn't know you were going to get history hit up here on the
right.
Secret Stash Nation. But yeah, what's interesting, though, is what came up. I don't want to get too derailed because I know we got some important stuff here in the joint tenancy issue. But what do you know how they did that? Was it literally like a court document, just like sort of it is today?
No, it's some statutes passed so that they could, in various states.
Yeah.
This is living trust are created by states. All 50 states have some version of this.
I see.
Yeah, and they all have their own version of probate too.
Interesting. We'll get you on for a second show so we can go down that whole rabbit hole. But I'd love to pick back up on that. So obviously wills pale in comparison to trust in a myriad of different circumstances. So we'll just agree with Marilyn right now with her 30-plus years of experience, and we trust you on that. Now, let's get down into the weeds like we talked about. So a lot of people hold their properties in joint tenancy almost by default.
Right.
Right? So maybe you could talk through, like, what are some of the unintended consequences of that?
Well, that's the worst possible way to hold title.
The
okay?
worst possible way. You heard
Right.
it here.
Okay, so let's talk first about a Supreme Court decision from many years ago that still stands in place.
Okay.
It says that jointly held property can be seized to pay debts of either party. And there was a man that had a house, and he added his son as a joint tenant. The son had a big claim by the IRS. The man died. Actually, he wasn't quite dead. He was still, surviving or whatever. And they took the old man's house because it was a debt that the son owed, and they went to the Supreme Court, and that was all right to take the man's house. So we want to avoid that for liability reasons, okay? It could be the child you're adding as a joint tenant could have bankruptcy problems, they could have marital problems, they could be in an accident, and you could lose your property.
Yeah.
Let's talk about another thing from the child's point of view. If you give your child the property or you add them on as a joint tenant and they go to sell the property later, guess what? They have to pay capital gains tax. Now, if you give it to them in your will, there'd be probate. But if you give it to them in trust, there's no capital gains tax because what we get called in English, we'll just say it's no tax, but in legalese, it's called avoiding capital gains tax.
Yeah, I'm going to give you a point for that one, Marilyn. That's a big one.
Okay, so we have tax issues, we have liability issues. We have a joint tenant owner of your house. Okay, so if you want to refinance the house because you need to take some money, because you want to take a worldwide trip, or you just want to buy a new water heater and you need to borrow a little money on a home equity loan, guess what? You have to get permission from your joint tenant owner that you added on for convenience. It's your child. But they don't necessarily want to repair the roof or get a new water heater. And they don't necessarily want you to take the money out and take the worldwide trip because, after all, they're going to inherit less than, aren't they? So those are some issues. They could file something called a partition suit, and they would win. What happens is a partition suit is there's a jointly held property. Someone files a partition suit to get their half of the property. So you gave your house to your daughter, and you're going to own it with her. Okay, you're going to be joint tenants. And then 5 years down the road, guess what? She files a partition suit to get her half of your property, of your house. Can you imagine? It's hard to imagine that.
Yeah, because it would, I would seen situations like this maybe in different contexts, but they can actually, so I'll pose it a question, May. Can they force the sale in that situation?
Yes, they can force the sale, and they will win because they're a legal owner. They're on title. So we can talk about joint tenancy from now until dark, but there's lots of negative ways. If you have property with your brother, hold it as tenants in common, and then you can each do a trust holding each of your interests in the property. You don't want to have your half in the trust and them own it as an individual, because if they die, guess what? There's going to be probate.
And then what's also interesting about that, too, if I can add on, is that there's the joint tenants in common, which is probably the most prolific of the defaults, but there's also the unmarried joint tenants. And what I've realized over the course of watching this behave is that they're subject to different rules. And they're not, like when you go to close escrow or you close your refinance or whatever, those rules are scantily ever communicated to the people, right? And so do you, what can you share about that? Like when it's an in common, it actually behaves differently than if it's just unmarried joint tenants.
Right. Well, if they're tenants in common, it can go to their own heirs. If they're joint tenants of any kind, it'll go to the survivor. It won't go to their own heirs.
Right.
And maybe they didn't want it to be that way.
And that's huge. That's huge because they think they own half the property, and therefore, if the other half ends up falling, it's going to fall to their side. Not the case.
No, it's not going to fall
to the other side.
It's going to fall to the other side.
Exactly. That's huge.
And so what we want to do in that case, if they're unmarried, we want to do trusts. Sometimes they're mirror image trusts. Boyfriend agrees that girlfriend can live in the house for the rest of her life if he has the same language in his trust that says that girlfriend can live in the house for the rest of her life. And then on their death, it's divided between their 4 children. In fact, I had a couple came in not too long ago with their children, and they said that they wanted to do a trust. And I said, well, what assets do you have? And they said they had one asset, their house. And I said, how do you hold title? And they said, well, we hold it as joint tenants. And I looked at them and I said, who's going to live longest? And I said, because whoever lives longest wins. Now, they had just gotten married a couple of years ago, and they were quite elderly, and they were there with their children. And so I said, you know what? If Mom lives longer, she can choose to give it to her children, or she can choose to share it with everybody. But she doesn't have to. She can do anything she wants with it because it's joint tenancy. And joint tenancy takes place at the moment of death, unlike the will, which has to go through this process. So we want to, well, in that family, we did a trust, and we said that both the parents were trustees, and then on the second death, everybody would get their money. And it was shared between all the children.
God, that's so interesting.
But who can live longest wins in a joint tenancy thing.
Yeah. Yeah, and I don't know, but in my experience, that's not really something you get to choose too often. You know?
Right, who lives longest? Hey, we don't know what's going to happen in 2 minutes from now, right?
Exactly. Hey, don't wish that upon us.
No.
We're going to get through the show, Marilyn.
Right, we're going to do that.
What about the other side of it, though? So, like, is there, you know, I hate to just spend all of our time propping this up like it's just the panacea of life. Like, is there any unintended consequences to getting a trust?
There is one negative, okay? So you have to listen to this carefully, though, because it has a good fix to it, okay? When you refinance your house, most mortgage companies want you to take the property out of the trust. So you take it out of the trust, and 2 minutes later you sign another document putting it in the trust. And
why? Why do they care? Why do they want to do that?
Because they don't want to necessarily hire an attorney to read the document. Now, there's a few mortgage companies, and I had one of those recently myself when I refinanced, and they just let it leave the property in the trust. Most of them want you to take it out and put it back in. Now, if they don't put it back in, you come see someone like me to get it put back in. It's very important, because if you die and it's left out, guess what? We have an asset going to probate.
And Marilyn, I'm gonna jump in your coattails on this one. I can't tell you how many times I see that happen, where it was in, it came out. They said right, like the escrow company or whatever, said they were going to put it back in, never did.
Well, you want to make sure it's back in. Now, if it's not back in and someone dies, there's a special kind of petition that we can go to court and file to get it back in. And it's not as expensive as a regular probate. And I've had a number of those cases on other people's trust. They're called Hegstead petition. That's a technical term for it. So we do a Hegstead petition if indeed you had a schedule listing what your assets were. That's one of the technical little things that you want to make sure that you have with your trust. You want to have a schedule of your properties because it shows your intent to have things be in your trust.
Interesting. So it's another way of saying the trust had to have been done right in the first place.
Correct.
Yeah. Now, not to throw any of the online entities under the bus right now, but, you know, there's other places you can go and you can kind of do this on your own. You
know, doing it on your own is kind of interesting because I've read a number of those documents. There's one where it costs $25.
Right.
And it's worth about 25 cents, actually. There's maybe 160 provisions that should be in your trust. Mine happens to be, depending on the family, between 35 and 50 pages long.
Yowzer.
It covers all those provisions.
Right.
And, you know, occasionally when situations come up or laws change, could be case law, not statutes, we add more provisions. And so people come back and have their trust reviewed from time to time, and we sometimes change them to update with the current law.
I love it. Marilyn said it. It's all in the documents. So don't delay. Begin your estate plan today. Hanging out in the secret stash with Marilyn Shea, owner of Estate Preservation Group. You can catch her online at estatepreservationgroup.com. Coming up, gang. We're going to get into the thing no one wants to talk about, but we got to talk about it today because it's chief on the list of your estate plan, and that is planning for disability and long-term care policy. That's why we got Marilyn in the house. We'll be right back. Real Talk Radio, San Diego.